are audible. Just say again.
Hello.
Yeah, Manisha.
Yeah, is it audible? Yeah.
Yes, audible.
Okay. A very warm good afternoon to each and everyone watching this. I welcome you all to this grand new second webinar of Prabasi Odia campaign, a Start in Odisha initiative by Startup Odisha, Government of Odisha. Today's live webinar session is going to be all about IP, legal compliances, and company registration. So before we go ahead with the session and welcome our mentors to the session, I would request Mr. Rashmi Ranjan Sahu, Senior Mission Associate, Startup Odisha, to speak a few words for this webinar session.
Thank you, Manisha, for the intro. And I, Rashmi Ranjan Sahu from Startup Odisha, welcome all the participants to join us for the second webinar of Prabasi Odia campaign, that is Start in Odisha. And the main objective of this webinar is to just give few ideas about how to go for new company registration. And if you are having any patentable idea, how what are the legal compliances that you have to take care, and how you can protect your idea or innovations from others. So we are having very good mentors with us today. We are having Ms. Madhuchanda Pradhan. She is a company and she is already associated with a lot of incubators in Odisha and also supported a lot of startups in Odisha specifically. So she understood a lot what are the challenges that startups are facing. If I can say, we have also seen a lot of questions from startups that which company that I can incorporate is. It may be a private limited or an LLP. Why shall I go for LLP? Why shall not I go for OPC or not proprietorship? Then also a lot of questions are coming from startups that if I'm having an innovative idea, and if I'm sharing with you as a government also, then how far it is protected from the sources. Then also a lot of questions arises like what are the documents that we have to take care if we are going to create a private limited company, whether it is very much taxable and how to do the documentation. So whether we will go for a chartered accountant, whether we will go for a company secretary or any other legal things. There are a lot of, before I forget, Ms. Arya Tripathi and Mr. Dhruv Suri, who has also participated, and we combinedly done one workshop last year about the term sheets and other documentation that a startup should take care. And today we are very much obliged for them that they have also come again and trying to help our startups in Odisha. So this Prabasi Odia campaign and this webinar definitely going to give some kind of support and knowledge about if a beginner or a budding startup is going to start in a startup. So what sort of things they have to take care. So I wish all of you a very good webinar session today, and I hope that you will learn a lot from our mentors today. Thank you, Manisha, and you can continue with other mentors. Thank you.
Thank you, sir. Thank you for addressing. So now it's time to welcome you all. First mentor for this live webinar session, Mrs. Madhuchanda Pradhan, who is a company secretary having more than 8 years of experience in corporate advisory services, including secretarial, legal, due diligence, IPR compliance, labor legislations, and audits of different statutes and corporate governance. She is also a committed educationist with over 10 years of experience in teaching legal students and a visiting faculty to various educational institutes on subjects relating to law, including ICSI, Institute of Company Secretaries of India. We welcome you, ma'am, to this live webinar session. And now I would request you to take over the further proceedings of the session. Ma'am, you're muted. Ma'am, you're muted.
Thank you so much, ma'am. May I please get the access to share my screen so that I can show the presentation actually? Can you please enable the my screen sharing option so that I can share my presentation with everybody? So before starting my session, actually, as I got the introduction to this particular webinar, this is basically about to solve various questions relating to formation of a business entity. Like most of us here are the budding entrepreneurs. They want to do something. They have their own ideas of doing something, getting into new innovations, but they are mostly worried and confused about forming a business entity, because whenever they are moving to any places, everybody asks them to form a business entity. Because just for giving a small example, if anyone wants to register for a startup, then in case of your startup also you will get that option that the company must be a private company, private limited company, LLP, or it may be a partnership. So lots of questions coming to mind, that what are the different forms of business available, or as an entrepreneurs, what are the pros and cons of different types of business entity. So now I am here to solve this problem with my little bit of experience, what I am going to share with this presentation. So if you are worried and thinking of choosing a proper right form of business in order to start something, in order to execute your business ideas, whatever you are in your mind through your business organization, then most of the things like so basically the options what we get, like people suggest us go for a sole proprietorship, go for a partnership, go for a society form of business, or as one-person company, limited liability partnership. There are various options available under your formation of business entity. Like the business entity can be of different forms, and every forms have their own advantages along with certain disadvantages also. So obviously, before choosing any particular form of business organization, the person who wants to form that organization, they must be aware of advantages and the disadvantages along with your requirements. Like if you want to do this particular business, then what is the most suitable form of business available to you, basing on the advantages, disadvantages, requirements, your options. So you have to first choose the proper business structure for your organization or for your innovative idea which you want to inculcate through the business model. So if we will, just to take an example, if we visit to the Startup India website, they are asking for, it must be a company incorporated under the Ministry of Corporate Affairs, or it can be a partnership form of business, or else you can go for any limited liability partnership. Then obviously three things is coming to the mind, that what is a company, what is a private company, what is the requirement of going for a private company, or what is the benefit of forming a company over the partnership or the LLP. Like these are the questions which I am thinking of solving here with my little bit of experience. Like if you have options of choosing company, proprietorship, LLP and all, then through my presentation, I'll simply explain that what are the legal entity options available for a budding entrepreneur if he wants to form of entity. So basically these are the points which I am going to cover here, like what is an entity, how to form a business entity, and what are the factors to consider before choosing a particular entity structure. Then types of business entity and benefit of forming a company, because in most of the cases everyone asks that please go for incorporating a company. Then how to start a company and what are the legal compliances, though not in 100% coverage because that time constraint is there. Each and every point in a nutshell. So these are the basic. I think there is some problem with the connectivity. Sorry for the inconvenience. So in order to choose a particular form of business entity, like you have to go with different factor analysis, like the liability means what the company is going to bear in the future, what is the taxation aspect, what is the accounting aspect, how your business entity is flexible to the coming escalated factors or the future needs of the company. Cost of formation, obviously this is the most important thing. How to form a company means how to form a business entity so that it will be cost effective to the person, along with that business entity type must fulfill the requirements of every entrepreneur. So basically these are the factors to consider before choosing any kind of business entity. So filing means any formation of the paperwork, setting up the financial things, tax aspects, or you can say the contracts and all, everything, because this is not like a sole proprietorship, or you can say the individual business where the compliances part is very few, like only it attracts the income tax or some of the few other acts. But if this is a company form of business, then many aspects like your formation, legal factor, secretarial factor, accounting aspect, taxation aspect, your labor aspect, everything will come to the play. So before choosing any particular form of the organization, every person needs to analyze all these options. On the basis of these factors, if I will start telling you that it's like the business entity can be, basically this is of two types. One, this is your registered form of business, unregistered form of business. Either you can go for a registered form of business or else you can go for an unregistered form of business. So option is yours, but before choosing, obviously you have to analyze the different factors, that what are the unregistered forms of businesses available and what are the pros and cons of going with that unregistered form. So if I go with this unregistered form of the business, so basically this is sole proprietorship whose registration is not at all mandatory in case of India. There is no such provision also for the sole proprietorship registration. Or else the second option you will get, that is your partnership business. If this is a partnership, then because in case of your startup, India also they asked for a partnership. So partnership is what this is. In case of sole proprietorship, this is a single person, single entity business, while your partnership is more than two. And registration of partnership, this is under your Indian Partnership Act 1932, and again, which is completely optional in the hand of the partners. If they want, they can go for the partnership registration, or else they can skip the registration and they can also continue with the same partnership rate. That's why we are keeping this partnership under the unregistered form of the business. Along with that, we have it into undivided family type of business, which is again a family business, means whose registration is also not required. But mostly we are concerned with the registered form of the business. That what are the registered form of the business available in India? If we want to register a business entity, then how we can register that particular form of the business, or what are the other options available? It's like, if I go with this, then I am getting the first option, that is the business trust, or you can say you can go with the society form of the business, or you can say you can go with the company form of the business. So the most commonly form of business which is registered in nature, that is your company form of business. But if we are going for any trust or society, then trust is again a registered form of business, and the trust in India registered under your Indian Trust Act 1882, and whose registration is without registering a trust, you cannot go with the, you cannot start your business also. And if you want to go with the society form of business, again that's registration you have to take, that is Society Registration Act 1860. And the last but not the least, this is the company form of business under the Indian Companies Act 2013, and the company without registration is not at all a company. So if I will get all these type of options, that I can go for a proprietorship, I can go for a partnership, HF, trust, society, company, then obviously I have to analyze certain advantages and disadvantages of various forms of the business. So if I'll go with this sole proprietorship form of the business, then where the ownership and management of the business are in control of a single individual. If that single person will enjoy the entire benefit, entire profit, then obviously that person needs to take the entire risk of his business also, as there is no other partners available to bear that risk along with that person. So if you want to go for a sole proprietorship, then you don't need to take any kind of registration. Simply you can start a business by giving a particular trade name, you can open your bank account and you can carry on your business and you can enjoy the entire profit. Along with that, you have to bear the complete risk of your business. But transfer your shares to any other person. So maybe like in most of the cases, you must have heard that for mentorship, this particular organization, they are taking 2 to 3% of the equity share of a company. But if this is a one-person company, you cannot share your transfer, means you cannot transfer your shares also, maybe 1% or 0.1%. So this one-person company, though this is a company form of the business, but still you can say this is just a modified form of your sole proprietorship form of the business. The difference is that proprietorship is not registered and the one-person company is a registered form of the business. But whenever it is asked any type of requirement like your company must be registered under your Companies Act 2013, then if you have a one-person company, then also you are eligible to apply for those things where a private company is eligible. Then coming to the next, that LLP. Again, this is one more well-known thing, that limited liability partnership. This limited liability partnership, in the same kind of OPC, you can understand that this is also a modified form of your partnership. Your partnership is registered under Partnership Act, while your LLP is registered under your limited liability partnership, means it is governed under the regulation of LLP Act 2008, while it registered under your Companies Act 13. But if I just give you a brief comparison between your LLP and the partnership, the registration of LLP is mandatory while the partnership registration is optional. In case of LLP, you have to apply for a name approval, and in case of partnership, there is no such requirement of name approval. You can choose any type of name and you can proceed with the business form. And number of members, in case of LLP, there is no limitation, but in case of partnership, you can get a maximum limitation of 20 members. While the liability, this is the most important factor of differentiation between your LLP and the partnership. While the liability of the members in case of your LLP is limited. If I will say this is a limited liability, then obviously a question is coming to the mind that what is a limited liability? Why we are telling that this is limited liability, and in case of partnership, this is unlimited liability. Let's say, I'm just giving you a small example. If the share price of a company is per share is 10 rupees, and I have already paid 2 rupees to that particular, means nominal value of the shares, then my liability is limited only up to that unpaid amount. So here you can say my liability is limited in case of the company. But if this is a partnership form of the business, if this is a proprietorship form of the business, then this liability is not defined and this liability is not limited. You will get an unlimited liability. Whatever be the loss amount, whatever be the future consequence, there is no limitation on your liability. Rather, all the members, all the participants, they have to divide that particular liability in terms of, means in the ratio of their contribution to the capital. So this is a basic comparison you can say between the LLP and the partnership. Again, this is the NGO form of the business. We have another form, that is NGO. This is non-government organization. The people used to form NGO. You must have heard about it. So that NGO also can be registered in these three forms, either in case of your trust, or means in the form of trust, or in the form of society, or in the form of a company which is exclusively a Section 8 company. Means the company which is registered as a non-government organization under the Companies Act, they are called as a Section 8 company. So in this particular three forms also a company can be registered. And again, there are different aspects of trust. Why we will not go for a trust? Why we will go for a company form of the business? There are also advantages and disadvantages of these forms of the businesses. So if I will simply show you trust it, then if you want trust start taking it, you can simply start your business by taking the particular name, whatever you have given in case of your trust deed. Your Amol, this is the most commonly well-known society in India who is operating as a society form of the business. But coming to the important part of our discussion, that is company form of business. Company. Whenever you wake up in the morning, whenever you go to the bed at the night, the things come into the mind that what is a company, how to form a company, what is the advantages of company, why I'll go for forming a company. Then if this is a company, if I'll simply define what is a company, you can say this is a voluntary association of people, but this company is a registered form of the business, that is registered. The regulatory authority or the regulatory ministry of forming a company is the Ministry of Corporate Affairs, and that Ministry of Corporate Affairs, they have a particular website of their own. I'll also show the website here also in my presentation. So that is the only website which controlling the entire registration to winding up process of a company, and in between whatever the legal compliances are there of the company, you can also get most of the ideas from that particular website. So if I'll go for a company form of the business, so basically the question will be coming to the mind that what is the advantage or benefit of forming a company. The first thing is that company is a registered form of the business. So when it comes to registration, then the credibility of that entity is increased like anything. It's not like sole proprietorship or the partnership. If this is the unregistered entity, then if anyone wants to give some funding, give some investment to an organization, then obviously they will prefer for a company form of business. Rather, they will not at all prefer the sole proprietorship or the partnership, because the credibility factor is there and the existence factor is there. So if this is the company form of the business, then nowadays you can say in this 2020 era, this is very easy and quick to start a company. The legal compliances, the formation procedure, the government has made many things very much easier. That is ease of doing business. That initiative by Narendra Modi, our Prime Minister Narendra Modi. So this formation process is also so simplified that not at all difficult like the previous type of registrations. And it possesses a unique legal entity. Company is a separate legal entity having its own identity. It's not like the sole proprietorship, it belongs to the proprietorship. Partnership, it belongs to the partners. The property of the sole proprietorship belongs to the proprietors, and the property of the partnership belongs to the partners. But in case of the company, there is separate management between the shareholders and the directors. The property of the company is not at all the property, means own property of the shareholders or the directors. Various tax advantages are there. And in case of your credibility, obviously it will be ranked in the higher position. And the ownership in case of your company, this is the shares of a company can easily transferable, though in case of private company and public company, there are certain restrictions. So the shares means in case of fundings and all, in those cases, obviously the company can attract a good investment and good funding if the performance of the company is good. If the valuation of the company is increasing, then obviously it can attract the good amount of the investment. And transferability of the ownership. See, if in case of your partners, if you want to add a new partner or if any partner is going away from the partnership, then your entire partnership will be dissolved and again you have to form a new partnership. But in case of your company, the company is having a perpetual existence with incoming and outgoing of shareholders, directors. It will in no way it will affect a company's existence, because company is having a infinite existence unless and until it will be voluntarily or by so moto by the register they are not winding up the company, or you cannot applying for striking out of your company, the company will go on. It will not at all affected by any entry or any exit of the shareholders or the directors. Then if you have a company today, means if you have registered a company today in this 2020 and maybe after 2 months or 3 months you don't want to continue the business, but you have certain assets in your company, you have assets, then government has given a very good opportunity, that is you can declare your company as a dormant company. Means your company will be active but in a sleeping mode. Means anytime in the future if you want to revive that company to an active company, then that option is also available with you, so that your assets will be protected inside your company. And if you want to exit from the enterprise, winding up option is there, striking up option is there, like, and choices with raising a new capital, obviously this will be higher in case of your company form of the business, because company is having share capital. So if anyone is giving you the mentorship, if anyone is coming to invest in your company and they are asking for 2%, 3% equity for that, means in consideration of that investment, then if this is a company form of the business, then it is very easier for you to transfer that 2% or 3% equity to the investor in order to get a good investment amount. So basically these are the advantages, or you can say the benefits of forming a company. But obviously with every advantage there must be some disadvantages, because if you are a law abiding citizen, if you are means with a, if you are forming an entity with a mindset that you will continue the company with after complying all the legal requirements under different acts, like your Companies Act, Income Tax Act, GST Act, PF Act, SI Act. There are various acts applicable to a company, and if you are with a good mindset that yes, I will continue with my company but abiding by all the legal requirements, then these points are not at all a disadvantage for the company. Rather, these things you can say they are the regulatory compliance, regulatory, they will act as the regulatory guidelines for the particular company. But one thing is there, in case of your sole proprietorship, it's like one person company, there is only single owner, so the decision making process will be very fast, you can say, or entire decision is completely centralized in a single person's hand. But in case of your company, there are shareholders, there are board of directors. In some of the cases, you have to take the approval from your shareholders. Then you can say this particular organization, this is not controlled by a single individual like your proprietorship. Rather, this is controlled by a group of person. You can say they are the shareholders or the board of directors. So though the decision making process is not centralized, rather it is decentralized between the shareholders and the directors, and there are other parties also, the stakeholders are also there, then there may be some delay in the decision making, and again it's subject to the corporate taxes and dividend distribution taxes, though this is a tax matter. But still, if this is a company individual form of business, means if this is about taxation of an individual, then you will get a particular slab rate, means up to this particular limit you have to give this much of the income tax, and if you cross that limit, then this amount of the income tax. But if this is a company form of business, then you will get you have to give a fixed rate of the corporate tax. That is, previously it was 30%, but government has again reduced all these percentages to 22%, 25%, and 15%, depending upon your exemptions and the deductions, whatever you want to claim. And excessive government regulation. Why this is excessive government regulation? Because in case of a proprietorship partnership, they are not at all registered form of the business. No need to comply with any kind of government regulation unless and until you are doing, means you are performing a business in a very simple way. By taking a minimal compliances under the income tax also, you can carry on your business. But if this is a company form of the business, then you have to comply with all the compliances, guidelines, acts applicable to your company. Maybe Companies Act, Income Tax Act, GST, Provident Fund, ESI, etc. So excessive government regulation cannot be a disadvantage if you are a law-abiding citizen. Then, in case of company, also again coming to the mind that what are the different types of companies available. One person company, you can say this is also a form of private limited company, your OPC. But again, you have one more option like public company, private company. Here I discussed about your Section 8 company. Then the questions like private company. What is a private company? What is a public company? So not in details, but just to remember, in case of your private company, the shares are closely held between the family members, or you can say the friends. The shares are not easily transferable. The shares cannot be traded in any stock exchanges like your public company. And in order to form a private company, at least 2% required. That 2% may be common as directors and the shareholders, and your stocks cannot be traded in any kind of stock exchange. And if you want to transfer your shares also, they can only be transferred within the close relatives, or you can say the family members. Means there are certain restrictions for transferability of the shares. But if this is a public limited company, then stocks are widely held and they are traded in the stock exchange, but minimum 7% required to form a public company. In most of the people, when they come to me, they used to ask that whether this what is a public company. They are the government companies. See, there is no connection between your public company and the government companies. So public companies work where minimum 7 number of shareholders are there and 3 number of directors are there, but their shares are easily transferable and they can trade their shares through the different stock exchanges. And coming to Section 8, this is again another form of the company form of your business, but basically the NGOs, those who want to do any social benefit activities like education, development of art, science, commerce, they can go for the section, means they can go for the type of the company that is your Section 8 companies. So the first thing is that when it comes to a company form of the business, maybe a question comes to the mind that what is the capital? What is the capital requirement for a company? Means if I want to start a company, then what is the minimum capital requirement? Then let me clear you this particular thing, that there is no minimum capital requirement for formation of any form of the company. Means you can start your company with a 1,000 rupees of the paid-up capital. Also, previously the capital requirement clause was there. For private it was 1 lakh and for public it was 5 lakh, but now there is no such capital requirement clause. You can start your company with a 10,000 rupees also. Means that 10,000 will be treated as a paid-up capital given by the directors. And coming to the formation of the company, see, the formation steps are so easy for formation of the company nowadays with the concept of that ease of doing business. So government has combined every previous forms which we are applying. Means obviously you cannot incorporate a company of your own. You have to take the help of a professional. So only 4 professionals are allowed to certify you for incorporating a company. That you can say a company secretary, chartered accountant, cost accountant, and the advocates. So they can certify you for formation of the company. And here I want to mention a single point, that if you want to incorporate the company, then along with your incorporation certificate, right now there are 10 services included in the company form of the business. It's like if you want to go for registering a company, along with getting your company registered, obviously you will get a registration certificate, that is called certificate of incorporation. But with that same cost, you can get another 10 plus value added service, which is the free offer, or you can say the value added offer given by the Government of India. That along with the certificate of incorporation with the company registration, here you are getting your PAN number, your TAN number, your Provident Fund number, ESI number, bank account number, commencement, GST. All these services you are getting in a one-stop solution. Means no need to apply for separately. Means after getting your company registered, no need to apply for this PAN number, TAN number, PA, ESI, means bank account also, opening of this bank account is also nowadays available with the incorporation of the companies. And no such physical forms were there for incorporating company. The government has made this thing so simple that a combined way form is there, but certification by a professional is a must in case of formation of the company. So if this is a Odisha based company, then the authority to approve your company is the registrar of the companies, which is situated in the Cuttack. And the costing of registering the OPC and private limited, everything you can get in, means the details you can get from the Ministry of the Corporate Affairs website. And the duration of the registration, you can say you can get your registration within a single day also if you are providing every document in a legible way and as per the requirement of the ministry. Then this is the website of your Ministry of Corporate Affairs, where you will get a complete solution to the formation of the company, to your striking up and the winding up of the company. So if anyone, any entrepreneur, if you are interested, then please visit the website and get the detailed idea about the company. You will get answers to all your questions in this particular website. And coming to the last, but yes, the last portion of my discussion, that what are the basic documents required for registering a company, then there are no such high documents like, yes, these are the documents required. These are very simple documents for directors, that like your PAN number, Aadhaar number, and for means towards an identity proof, you can give either your driving license or your voter ID or your passport copy. And towards the address proof of your means of individual director, or you can say the shareholders, then the companies, means the government is accepting your bank statement, electricity bill, telephone bill, mobile bill, any document which is giving a legible proof of your address. So basically these are the 4 documents only with which you can go for the incorporation of the company: your PAN, Aadhaar, voter ID, or you can say the bank statement. And the most important, wherever you want to make your registered office, for that particular address you have to give the registered office proof, that is the electricity bill of that particular means that particular premises, or any landline bill, telephone bill, mobile number, means postpaid mobile connection bill, or the gas bill also will suffice the requirement of the registered office. Apart from that, if any affidavit is required, like memorandum, articles and all, this is to be drafted by the professionals. They will draft on the basis of your given documents. And as I mentioned, no individual name approval is again required for incorporation of the company. Means along with entering into the name approval option, in a one shot you can also go for the company incorporation. So because this company incorporation process is nowadays so easy, but one thing you have to keep in mind, that you have to get your company certified from a professional. You cannot go for the company incorporation, because in most of my seminars I got this question that can we incorporate our company of our own? So the clear cut answer is no, you cannot go with the incorporation of your own. You have to take the certificate from the from a professional. And in case of our company formation, instead of any physical signature, there are signatures, maybe like physical signatures, electronic signature. The signature what we give while obtaining the driving license, or while transferring any property, they are, you can say, the electronic signature. But in case of your company registration process, the signature which is used, that is called the digital signature. This is your DAC, or you can say the digital signature certificate. These digital signatures are the electronic form, means digital form of your physical signature, which are as good as valid as your physical signature. Means the authenticity and the validity of your digital signature is as equal to your physical signature. Wherever in case of means this digital signature also can be used in case of your MCA related activity, that is Ministry of Corporate Affairs, income tax, ROC, GST, or if you want to apply for any tender also, this digital signature will be used. No physical signature is required, and you cannot go for a physical signature also. You have to obtain a digital signature of your own. Means every director, every shareholder, they have to obtain a digital signature. Means they have to sign, because the registration process is not manual. Previously, before 2006, the registration process was manual, but after this IT Act, the registration process is completely digital. Then when the registration process is digital, the forms are available in the web form, then you have to, instead of your physical signature, you have to use the digital signature. And for obtaining this digital certificate also, the documents are basically the same. That is your PAN card, Aadhaar card, and the passport size photo. So with this limited number of the documents, which you can incorporate a company. For incorporation, the time limit is very less, and along with the incorporation is your certificate of incorporation, you can get all these services as a value-added service along with the incorporation process. No need to go for any separate type of the registration, or no need to apply for any separate PAN card, separate TAN card, separate PF, ESI. No such provision is available also. So I guess I am able to make you clear that what is the basic concept of business entity and what is the benefit of forming a company, or you can say the steps for incorporation of the company and documents required for incorporating a company. So now it's the time to take a moment to breathe. So thank you so much. I think I am completely done with my presentation. So over to you, Manisha ma'am.
Thank you, ma'am. Thank you for sharing the brief insights about the topic and sharing your valuable knowledge to our attendees. Thank you so much. Now, before we go ahead in the session, I would request each one of you, like if you have any questions and you want our mentors to address them, please make sure you drop the questions in the chat box so that we can address that in the end of the session. So it's time to introduce you all to our second mentor for today's live webinar session. He is none other than Dhruv Suri, who heads the PSA Startup Venture Capital Private Equity Practice Group and actively advises multiple startups, venture funds, angel investors, and family offices across a range of practice areas. Some of the sectors where he actively advises clients are healthcare, telemedicine, e-pharmacies, hospitals, pharmaceutical manufacturers, etc. Additionally, he also co-heads the dispute resolution practice of the firm, where he represents clients before multiple forums across India. He regularly appears in the district courts, high courts, Supreme Court, Competition Commission of India, National Company Law Tribunal, National Company Law Appellate Tribunal, etc. He regularly speaks at conferences as well as conducts trainings at incubators and accelerators. We welcome you, sir, to this live webinar session. Now I would request you to take over the further proceedings of the session.
Thank you. Thank you so much. I hope I'm audible. Can you hear me? Yeah?
Yes, clear.
Okay, great. Thank you so much for that. Thank you so much for that introduction. A very good afternoon to everybody. Madhuji, thank you for that wonderful presentation. It was extremely enlightening and extremely important for early stage companies, for entrepreneurs who want to understand the different entity structure options they have, keeping in mind what their long-term plans are going to be. But I want to take a step back. I want to take a step back from the stage of incorporation. I have my colleague here, Arya Tripathi, with me as well. Arya, if you can just wave to everybody. Thank you. And I want us to think about what is the most fundamental thing that we actually have to think about when we start businesses, right? And I'll give you a short story. Many years ago, I decided to set up a backpackers hostel with a friend of mine, okay, here in Delhi. I'm a lawyer. I told him, of course, I'll help him with all the paperwork, all the compliance work, all the documentation that is required. And we shortlisted a property. We said, look, we'll source our beds and bunk beds and ACs and fridge and kitchen equipment, made a whole business plan around it. And now we got to that stage where we actually had to incorporate the company. I'm sure this is the cycle that most founders follow, right? You brainstorm what you want to do, you decide who's going to do what, and now it comes to the stage of company incorporation. Our business never picked off. We never did what we actually thought we will do, because the one discussion that happened in my office was, okay, we are two friends, we are starting the business. How do we split equity? I was like, of course, we are two good friends, 50-50, what's the problem? But that's never the answer. The answer is never to go 50-50. The idea is always to understand who's bringing in what on the table. Okay. A lot of founders, when they start off businesses, and I have seen this because it leads to disputes, it leads to problems, it leads to subsequent fundraising rounds going down the drain because there is conflict that emerges between founders and especially younger founders, right? So imagine a situation if Arya and I decide to start a company, we decide to be 50-50, and for some reason the company is not picking up as we expected it to, and then Arya suddenly decides, look, this is really not working out. I want to now go for my MBA, or I want to go and study some more, or I'm taking a PR to Canada and I'm moving. What happens? Like Madhuji explained, you have a company in place, there is shareholding, there are certain rights that people have in that entity structure. You can't just disappear one fine day, decide to go. So how do you try and protect a situation like this, right? What is very critical in this is that if you're about to start your company, you need to ask and what I call difficult conversations. You need to have difficult conversations with your fellow co-founders. And these difficult conversations are about what is the long-term plan? Where do we expect this company to go? What happens if we run out of our initial funds and are not able to raise money? When should we raise money? We are two people or we are three people. We are going to be on the board of directors as well. But what happens if we have a conflict of opinion? Is there anybody who will have a veto power? Is there anybody who will decide in case there is a dispute between us? What happens in scenarios like that? And I will tell you practically, I have actually had instances where I have had founders come to my office and these discussions have become so heated that I have made them write on pieces of paper answers to certain questions and then ask them to fold it and give it to me and read it out to them, just so that we are clear whether everybody is on the same page or not, right? So this is critical because you want to make sure that your equity is divided very well. Now, in the example I gave you, what was my contribution? I was putting in money. If I'm simply putting in money and helping in with some legal work that anyway could have been outsourced for that backpackers hostel to any other lawyer, I'm bringing in absolutely zero value addition. So what is my basis of even claiming 50%, right? And at that point of time, my friend proposed, oh, look, I'm going to be running operations. I'm going to be running pillar to post. I will sit at that hostel 24 hours. I will manage every logistical operational issue, marketing issues, social media. Your role is very limited. Why should there even be a 50% split? And in hindsight, I agree, there shouldn't have been. Right? So I think this is a very critical question that founders have to talk about, have to discuss before they incorporate their company, before they set up any kind of shareholding structure in their company. Because if you don't, and you come across situations where one of you decides to leave, or there is not alignment on the future business potentials. What if you decide that, look, there are these 10 customers I will make a pitch to, they don't agree to take your services. Now suddenly you're back in the doldrums. One person has another strategy, but everybody else doesn't agree. And these are actual practical problems that happen. Okay. Now, what is the way around it? How do you actually come to a solution? What is the solution for this problem? I would say, generally speaking, there isn't any, right? There isn't a solution to the problem, but there are ways to mitigate risks. And one of the ways to mitigate risks is to have a co-founder agreement. Now, people talk about it. I firmly believe that early stage companies need to spend money on good accountants. And that's it. Okay. Lawyers are people they should be the last service provider that you should be approaching. Right? So I am not somebody who actively proposes that early stage companies should spend thousands and thousands of rupees in getting very sophisticated co-founder agreements drafted. But I do think that as a co-founder, it is your job to be a jack of all trades. You can't, as a co-founder, say that I will not know anything about intellectual property because I am only a tech person. I will only code. I will not know anything about marketing. I will not know anything about finance. I will not know anything about legal. No, you can't do that. You can't afford to do that. You need to be somebody who knows a little bit of everything. Okay, you need to be a jack of all trades as a co-founder. no matter what business you're in, no matter how much you hate doing something else. With that in mind, it's very important, like I said, you need to have these initial discussions with your co-founders. And then there are today enough accelerators, incubators, law firms, and even online on the internet, you will find multiple templates of agreements. And again, I don't endorse templates by any means. And I'm only talking about situations when budgets are tight, you don't really have funds to spend on external lawyers. It's a way to mitigate risk where you get hold of an agreement from one of these incubators or accelerators, read through it very, very carefully, discuss all these different issues with your co-founders, and then try and perhaps incorporate it yourself. And if you're not able to, then perhaps engage a lawyer or a company secretary or whoever can actually add value and close that document for you. The other thing that founders actually have figured out a creative solution, and of course it needs to be legally tested in court, but it gives comfort even to potential investors, is actually agreeing to some sort of a vesting schedule, right? So what does that even mean? I'm sure you must have heard of the nomenclature vesting. It effectively means that, look, we are today agreeing that while we have subscribed to a certain capital in a company, like Madhuji had explained, you have something known as a paid up capital, which is how much money you have physically put into the company and taken shares from the company. You decide that these shares that you have actually purchased contractually will vest upon you slowly. Therefore, if after 6 months or after 1 year, one of your co-founders decides not to be as actively involved as he had committed he is going to be, you will have a right to say, okay, therefore only 5 or 10 or 20% of the total shares that you were supposed to get have vested. The rest will have to be taken back or bought by the other co-founders, etc. So that arrangement can be worked out, but effectively you don't let that other co-founder take the benefit of the initial shares that he had subscribed to if his role gradually in the company reduces. Okay. And this is again a deal breaker when you start raising money, because when you will go to your first investor and you will introduce to your co-founders, they will ask, okay, what do these co-founders do? What is the role? And then when you say, well, this friend of mine who was a good friend with who I decided to set up the company, we were 3 of us, he took 33.3% from me, but today he's nowhere in the picture, he's not involved. That's a huge red flag for investors, because the investors are now putting money for somebody else to earn through an inflated share value. They will never do that. So while it doesn't seem like a problem upfront, trust you me, when your company starts growing, you will realize that this actually has serious repercussions, right? So this is something I want to leave with you as a thought, that learn to have difficult conversations with your co-founders early on. And if you're not aligned, if you don't have the same vision, and it's not even an age-centric thing that younger people have these problems. I've actually been advising companies where the founders are 60-plus-year-olds, very veteran businessmen, and there have been conflicts even amongst them as to what their role is going to be. And what happens when somebody gets a better opportunity elsewhere? How do you actually tackle a situation like that, right? So it's something that you definitely need to think about, and you need to ponder over before you incorporate a company. Now, once that's done, you've incorporated the company. Now, what is the first thing that you're actually thinking about? And I'll again tell you a really interesting story of a client of mine, a company that was funded by Nexus, Sequoia, and Bloom. Okay, so fairly well funded, raised a lot of money. The co-founders of this company, when they decided to name their venture, right? They were all sitting around in their living room, joking around, oh, what should we call it? This is what we are going to do. They joked about it. They came up with a really interesting name, which they thought was the best name for their venture. And they were like, perfect, we're going to start business doing this. They started the business. Okay, they all loved the name. Investors loved the name. It was very creative. They spent a lot of money making creative marketing material around that brand. And then, while they were about 7 to 8 months into their business, by which they had raised money, one fine day, they get a legal notice from a company which is almost in the same business. I would not say it's in the same business, but had a trademark which was very similar to the mark that they were using, except this company, much smaller in scale, had a registered trademark with the trademark authority. So they sent a notice saying, look, you can't use this trademark anymore. Now, these guys were like mid 20-year-olds, okay? They didn't even understand what a notice was. They ignored it. The company tried to go to their other offices, and you know how it is, an early stage company just about to scale up. You don't even have like proper SOPs in place. They had opened up an office. They were Bangalore based. They'd opened up a small office in Delhi, a small office in Jaipur, a small office in Bombay. You don't even have co-founders who are actually sitting over there. You have maybe like part-time guys who come over there to work from there. So they actually sent like some notice to one of these offices. Nobody responded. Nobody took it seriously, because why should they? Business is going great. They've just closed a round of money. They're acquiring customers like nobody's business. And then these gentlemen here in Delhi, the company's based out of Bangalore, they filed a lawsuit against them for a trademark infringement. Okay. When they filed this trademark infringement lawsuit, they managed to get an order from court saying that this company, which is this client of mine, should immediately refrain from using this mark anywhere. Now imagine what that means. They spent marketing materials, money in creating marketing materials, in promoting, had a domain name that they bought. On that domain name, there was actual e-commerce happening. Now, when you get a court order saying, stop using this name, that means your website needs to go down. Now, imagine if you're actually generating revenue from your website. What do you suddenly do? You've created marketing material. Your guys are out on the streets wearing t-shirts with your brand. You've distributed those t-shirts for free during some marketing promotion activity event that you organize. There are people wearing that. How do you stop them from now using that brand? So imagine overnight, their business came to a standstill. And if you actually do a little bit of a post-mortem of this happened because they were all very excited about their name, but nobody at that point of time bothered to do a simple due diligence of whether they should actually use this mark for their business or not. And there is a very big misconception amongst founders, and it's interesting because it comes up all the time. They believe that if they bought the domain name, they can use the mark. The answer is no. That means nothing. Okay. Just because there is a mark as part of your entity name, that also means nothing. Entity name also doesn't matter. So like we were talking about incorporation of a company, and most of you would probably know, Snapdeal, right? Like that's the brand. That's what they have registered. That's what they do business under. That's the brand that can possibly be confused with another brand. You don't know what Jasper's Infotech Private Limited is. That's actually the legal entity of Snapdeal, right? But nobody knows of that unless you're raising an invoice or making a payment. Then you know the name. But otherwise you don't, right? So just because you bought a domain or just because your private limited has a certain name doesn't give you the right to use it. Now, all you had to do was, before coming up with that name, do a simple trademark diligence, right? It doesn't cost money. It's fairly straightforward. And what that could have done, and this is what I give this example of my client, and in fact, they talk about it when they speak at different webinars as well, that one little careless mistake or carelessness in general cost them more than 50 lakh rupees in fighting out this entire battle where FIRs got registered, etc., 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 because a company that was so well funded, this other smaller startup with a registered trademark tried to arm twist them into saying, "Mera hi brand kharido, buy my brand from me, and the dispute is over, but I will charge you some 5, 6, 7 crores." So you don't want to get embroiled in issues like this just because you did not do a very simple step of actually doing a trademark search. So what I also recommend early stage companies, and this was my way of talking a little bit about IP to you people in very simple layman parlance, that look, IP is a very critical aspect of any business, okay? But at the same time, it's important to understand whether it's critical for your business or not. So a lot of people will come and tell you, oh, you've incorporated your company, time to spend like thousands and thousands and lakhs of money on protecting your IP. No. You don't have to do that. If you don't have budgets, and if you're not a B2C company and you're perhaps a B2B company, you don't even need to register like all kinds of permutation combinations of your logo upfront. Save money. Maybe just register the domain, the word mark. So if you are selling under Snapdeal, register SNAPDEL, the word Snapdeal. All your different logos with red and white and blue and black, wait. Let your business pick up, get some cash flow. Those are things you can subsequently do as well, right? So you also need to be intelligent about when is the right time to actually start spending on your IP? It's not at day zero. Sometimes it is, right? If you're actually a consumer facing brand, if you come up with a brand of cosmetics, yes, because you have inventory in production. You have products that are being made with packaging and labeling. And suddenly if you realize medicines, right? It's a huge issue in the pharma world. If you have actually come up with a name and there are medicines being manufactured and packaged and wrapped and being sent across multiple pharmacies across India, and suddenly you are told that you can't use the name paracetamol, what do? You have to call back all your inventory, right? So over there, it's important to do that diligence. But if you're a B2B company, you need to know what kind of money you need to spend and at what stage of your business. And trademarks are fairly simple, right? I don't want to get into what is the process, but you file your application. More often than not, there'll be a minor objection raised here and there. You file a reply. Most applications will then, there'll be some sort of a hearing. If there's no hearing, they get advertised in something known as a trademark journal. Once they're advertised, then any third party has a right to file an opposition if they feel that you are actually going to infringe upon their mark. If that also doesn't happen for a 4-month period, your mark is registered. The trademark registry is generally a little slow, so it takes a little bit of time, but it's not a very complicated process. But don't fall in the trap of just registering your mark till you've not done that preliminary diligence. Then I want to briefly touch upon copyright and patent because I know a lot of people talk about it. And then I'm going to ask Arya to talk about certain commercial contracts which are very critical for startups, right? So now when you talk about copyright, the problem is most startups say that, oh, listen, I have an idea, I want to get it patented, right? So there's a lot of interchange. You use these IP concepts interchangeably. You have to understand ideas get no protection under Indian law. You may have come up with a great idea. Chances are that it's not going to get protected. And if somebody tells you it is, there is a big problem because you'll never be able to enforce it. And if you will, it's going to be a very minuscule exception in law under which you'll be able to do it. So the general rule has to be that ideas don't get any protection. Okay. But what do you actually copyright? So copyrightable work is like literary work, your cinematographic films, etc., etc. But in your world, if you're looking into the tech space, your code is what you actually get copyrighted. Okay. There's no patent for a code unless you come up with a way that there is hardware and software integrated where there's a process that you've created for which you go and file a patent. But independently, if you've come up with some proprietary, very sophisticated, very classy code, you can file for copyright protection. But trust you me, that process is extremely tedious, where you actually have to give like printouts of your actual code, screenshots of what happens. You need to run it on a CD and give it. And a lot of times people are also not comfortable sharing that with the copyright office because they feel that, oh, if it's actually that proprietary, chances are it may actually get leaked from there, right? So as a matter of practice, a lot of people don't necessarily file for copyright for their code. Those who do are typically large companies. Now, if you're writing a code for an e-commerce website and you're like, oh, I'm a genius, I've come up with this code, I need to file for copyright registration, and you come to me, will I ask you to do it? No, never. Too generic, you may think you're a genius, but the short answer is there are 1,000 other people who come up with something like this. You're not likely to get any protection. Don't waste your time as much as you think that you deserve that copyright protection, okay? Very different from what you think you deserve versus what the reality is sometimes out there. That's on the copyright bit, right? So if you have questions, we can take it up in the Q&A as well. And then of course you have patents in terms of what can actually get patented. And you've got to have something that has industrial application. That's the critical aspect in terms of in terms of what is the right that how you are actually going to use what you are getting a patent for. It needs to have some level of novelty, right? Something that's already out there cannot get patented. So if you think you have come up with something, which involves a certain level of hardware, or it involves a certain process through which you're increasing a certain kind of efficiencies. I'll give you an example. We recently filed for a provisional patent for a company that did something very interesting, which built this whole process that actually involved being able to pick up from social media websites across the globe adverse events that people were reporting with certain drugs. But now the thing is, drugs are not necessarily given the same name globally, right? So you may actually have a situation where a drug is called something in India, something else in the US, something else in Israel, something else in Australia. So to be able to figure out what the common salt is and be able to collate all that data of somebody tweeting, oh man, I actually had XYZ medicine and it's giving me a stomach upset, that data being able to pull out. So they created a whole process around it and filed a provisional patent, where there was a element of industrial application for what they were trying to do. And this was a right case for them to get a patent. So it's still at a provisional stage. We'll see what happens. But this, I just wanted to run by you what these examples are. I have a few more things which are on a slide, and I can share that if we have time, or if you have questions subsequently on what is actually patentable and examples of different patents. Maybe I'll share the slide then. But I also want to have Arya step in over here because she's going to talk about commercial contracts for startups. Very important because you don't necessarily have the power to negotiate them at such an early stage. And therefore, what Arya is going to talk about becomes even more relevant because you need to know what you're signing on. Okay, so over to you, Arya, but I'm happy to take questions. And I think towards the end, Arya, I want to briefly talk about another red flag for early stage companies with respect to Esops. So maybe when you're done, give me a moment or two and I'll come back on Esops.
So as Dhruv was saying, first and foremost, thank you, Madhu, for brilliantly and succinctly summarizing the do's and don'ts and the essentials for how to set up a business entity. And Dhruv, thank you for giving certain practical insights onto what founders have to really think about. It's just not all about paperwork or getting a company incorporated, but there are a lot of practical situations that one definitely needs to consider. First and foremost, like Dhruv said, ideas are not capable of any sort of registered or statutory legal protection. So what do we do about certain ideas which we think have proprietary value? How do we protect certain business strategies which have a bearing on our business? So there are certain things called price sensitive information. Now, certain market analytics could be equivalent to price sensitive information. There could be certain way of doing things, certain processes that you follow that helps you expand your market. All of these could be clearly not protected under any of the statutory protections being design or software or patent or trademark. You cannot go, or geographical indication, you cannot go for these sort of protections. Then how do you prepare yourself, or how do you protect these non-statutory proprietary information in a manner that if there is a misuse of this information or this particular asset that you have, an intangible property, an intellectual property, then how do you actually protect it? A lot of times you would be required to disclose a lot of information to potential investors. Also, when you're trying to collaborate, or you're trying to onboard someone, or you're trying to get services from someone, in all these matrices, you are likely to disclose things which are not under the regular regimed protection for intellectual property. In all of these instances, you must. And when I say you must, I will also explain why it is sound to do it, but not probably practical to implement it. You must look at something called as a non-disclosure agreement or a non-disclosure clause in your contracts. Now, what exactly this means? It means that you obligate a particular party with whom you're sharing this sensitive information to maintain confidentiality. That is, they cannot go ahead and disclose it or start using it in any manner other than for the purpose for which it was disclosed. For example, when you are pitching for investment or funds to an investor and you explained your business model, then if there is a confidentiality obligation, which would be mutual, I am sure that there are mutual confidentiality obligations that you would see. It basically means that the party cannot use it for any other purpose. So they will use it for evaluating if they want to invest or not. They're not supposed to go and disclose it to somebody else or start using it in a manner which is not contemplated. Now, a lot of information can fall within the ambit of confidential information. And recently, a lot of people have been putting the whole idea piece, that this ideas, notes, concepts, strategies, marketing techniques, customer list, everything. So a generic confidential information that you would see in contracts would be very wide sweeping, and the idea is that if there is a breach which is identified, there is a potential that you may suffer certain economical loss, which if happens, then you can take them to the court, say that there was a contractual obligation and seek to enforce it. Now, sounds very simple, straightforward, but there are practical difficulties that you need to understand when you go to courts to enforce such clauses. The practical difficulty is that it is very difficult to substantiate that the loss number one happened because of a breach of confidential information. It has to be absolutely evident, first and foremost, that it was the confidential information and breach of confidentiality obligation that resulted in that loss. If there are other factors which are present, then in that case, the whole matrix gets diluted again. Further, confidentiality obligations also become difficult to enforce because to exemplify the loss or the actual money value of the loss becomes again difficult. How do you account for how much money you have lost? Despite the practical difficulties, it is always recommended, and in fact I would say almost look for including a confidentiality clause in each and every contract that you are signing. It could be a one-way. A one-way is where the disclosing party requires the other party to maintain confidentiality, or it could be a mutual NDA where both the parties to a contract, they agree to maintain confidentiality. Now, is it only something that you should look for when there are commercial contracts, like you are obtaining goods or services from someone, or you're providing goods or services from someone, or you got somebody to develop your web platform or do some work on the data that you have collected? No, it shouldn't be just limited to these sort of contracts. You should extend the scope to even employment contracts. A lot of time when you are hiring people, your employees are always privy to confidential information, and to that extent, it is very important that your employment contracts also include a confidentiality obligation. Now, from there, I would actually like to talk about other things that you would generally see in a contract, not just your investment contracts, but otherwise also, which you may think are complex legal concepts. And I will not say that they're not complex in terms of how you are going to enforce it or what it is trying to achieve. But my idea is to give you a broader understanding or a generic understanding of what those clauses mean. One is representations and warranties. Several times you would see in all sorts of contract that there are clauses which are called as representations and warranties. And the typical language would read that a party represents and warrants to the other party that, and there is a whole list that would be there, that you are formed in accordance with applicable law, that you have obtained all licenses and permits to operate your business, blah, 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 all of that is there, that you have competence to perform the contract. So all of those representations and warranties are there. Now, what are those representations and warranties? Now, representations and warranties become the fundamental premise basis which parties enter into a contract. So if I am representing myself as a lawyer, and because of which you are coming to me for legal advice, there is a representation that I have made. So the 1 point agenda of having probably longer representations and warranties is to strike at the basis of good faith in a contract, because contract has to be reasonable and people have to enter in good faith. The consent to a contract should be free. It should not be that somebody is coercing you or somebody has unduly represented something and therefore you entered into a contract. What if I'm not a lawyer, and what if I have absolutely no credentials to give you legal advice? So can you then go back to court and say that, oh, she told me that, yes, she's a lawyer? Now, yes, you can do that, but how do you prove it that I said that to you? So in order to ease out that process, typically parties put down their list of representations and warranties, which can be later enforced in a court of law. The related clause that is there is always an indemnification clause. Now, what is an indemnification clause? So I'm sure everybody here has a health insurance. Now, what happens? If you ever pick up your insurance policy, you will see the language that is used is that insurance is a contract of indemnity. Now, the moment you talk about indemnification, it is a standalone contract. Even if it is coming in a big contract, that particular clause itself is a contract in itself. So forget about everything else in the contract. Indemnification can be enforced as a standalone contract. Indemnification basically states that whenever the indemnified party incurs any losses or damages, the indemnifier is going to make up for those losses and damages. So how does this work? Now let's get back to the health insurance, which is a contract of indemnity. Now health insurance, you obtained it, so you are the indemnified party. The insurance provider is the indemnifier, and therefore when you are hospitalized, they pay for your bills. That is a contract of indemnity. But at the same time, you know that claiming money from insurance companies is not that easy. There are a series of processes that you have to follow. That is one part of it. They also take account of how much money actually has been expended on your treatment and whether it is covered or not. So a lot of diligence on that aspect is done. Now imagine if a certain claim that you made and the insurer said, no, I won't pay for this, and you want to fight it out because you have certain interpretation of the insurance coverage, you will go to court. Now when you go to court, what is a typical court proceeding going to look like in this particular matrix? It is going to look like exactly the same way like any other court proceeding, where you have to substantiate what amount of loss you have actually suffered. Merely because you have an indemnification clause does not mean that you send a letter to the indemnifier and say that, okay, this loss has happened, or a court case has been filed against me, or a third party has claimed, so I need for you to pay me. That is never going to happen. It is only going to happen when there has been an actual loss that you have suffered. A lot of times I have seen that people get scared by the whole idea that, oh my God, I'm giving certain representations and warranties, and then I am again giving certain indemnification to the other party. And it is difficult to convince the other party as to why you will not give indemnification. My simple point of bringing this whole piece is that these are certain clauses that you should not be wasting your time on negotiating a lot. You should probably just not be so fussed about an indemnification clause in your contract. But when you talk about representations and warranties, make sure that you do not provide any factual misrepresentations. So if you read them and you think that this is something that your company doesn't do, or your company is not planning to do going ahead, or this is something that is incorrect in fact, then you should say that this is incorrect in fact and carve that out from the representations and warranties. Another clause that you would often see, which I do not know if how many of you have already registered and working as companies, or how many are planning to. There are clauses around limitation of liability. Now, limitation of liability, what does that mean? It basically means that the law itself, that is the Indian Contract Act. So every contract, today if I promise that I'm coming for the webinar and I don't come, is that a contract? Is that something that can be enforced? The answer to that is a simple no. There are three facets to any contract. There has to be an offer. The offer is that you want to sell a particular product for, say, 10 rupees. The acceptance is that the other party comes and says, I am buying it for 10 rupees. And then performance will be where I hand over the product. He or she pays me 10 rupees. That's performance. But what is that 10 rupees? That 10 rupees is the consideration. So consideration is anything that is in cash or in kind. Unless and until these essentials are fulfilled, there is no contract. It is just an agreement. And let me tell you that every agreement is not enforceable under law. An agreement which is enforceable under law is a contract, and it essentially needs to have these four things that I spoke about: offer, acceptance, consideration, and performance. Now, moving from here, there is a law that regulates contracts, which is called Indian Contract Act. It has several requirements as to that the parties' consent has to be free, that if there are reciprocal promises, both parties should be fulfilling those promises, blah, 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 which I'm not going into right now. One of the important parts is the concept of damages. If your action results in me incurring certain losses, then in that case, what is my recourse? My recourse is that I can recover those losses by filing a suit claiming damages. Okay. So a lot of times if you are looking for starting a business where you have B2C interface or a B2B interface, where you are going to provide certain kinds of services or goods, it is very likely that you would be encountering situations where you receive notices that, okay, this good is defective or this service was not performed. And then it has the potential of escalating to a dispute. So the law on damages as provided under the Contract Act simply put says that you can recover direct losses. Now, what is a direct loss? Now, if I say that I am going to serve biryani to people, and instead of biryani, because of that biryani, if somebody, fell sick or was unwell, then and had to incur medical expenses, that could be an example of a direct loss. And that is the limited extent to which courts recognize the concept of damages. It is very difficult to go beyond and say, oh, because of certain things that you did, I lost a potential business. So if I had bad biryani and I went and gave a review on, any of the websites or even on my Facebook, then the person cannot come and say that, oh, because of your review, my business went down and therefore I have suffered losses. That is a case of indirect loss. So a lot of times in contract, you will see a clause which is called limitation of liability. Now, limitation of liability simply states that the limit of damages that you can actually claim would be to that of the direct ones. Indirect ones, exemplary ones, punitive ones, all of this is excluded. Do not worry about such clauses, because that is a legal principle which pretty much even without that clause will apply if it has to be enforced. That is limitation of liability. Also, there are clauses around scope of services and scope of goods. Now, the first and foremost part, as I said, you remember offer, acceptance, consideration, and performance. These are the fundamental clauses in the contract, which lawyers call commercials. So you need to review them clearly when you are seeing a contract, which you have to sign, to understand that it captures exactly what you are promising to do. It should not capture anything that you have not agreed to or you have not negotiated for, and it should not miss out on important things which you want the other party to perform. So offered, acceptance, performance and consideration, and this I'm saying is for all contracts, be it you hiring an employee, be it you hiring any service provider, be it you providing services or goods to anyone. Either way, these are important clauses that you need to see. So we spoke about the material parts of the contract, your representations and warranties, your indemnification, your limitation of liability, your confidentiality obligations. Now comes intellectual property. Apart from confidentiality, there are a lot of times you will see that there is a separate clause in intellectual property that is drafted. And those clauses, in a sense, simply try to set the stage clear as to who owns what intellectual property. In certain contracts, such as, say, collaboration contracts, I've seen in the Q&A a lot of people asking questions with respect to Section 8 company. Now, I have worked with a lot of Section 8 companies where they have, say, collaborated with an Infosys, or they have, say, collaborated with a Wipro, and these organizations, as part of their CSR activities, they have come up with, say, a software. They have come up with an application. They have come up with, say, any other technology that helps the Section 8 company to have better social impact. Now, a lot of times what has happened is, because of this contract or collaboration that they did, there's an intellectual property that has come up, which is in the form of a software. Now, whether it is licensable or not, whether it is can be registered or not, as Dhruv said, is something that has to be seen on a case-to-case basis. The idea of having an intellectual property clause is to ensure that between the two parties who developed that, or who are privy to that intellectual property, they give certain assurances and they clear out certain terms. Assurances as in the fact that this is not created by breaching somebody else's somebody else's intellectual property. Clearing out certain things as in who is going to own it. Are they going to jointly own it? Are they going to own it independently? What happens to intellectual property that somebody brought on table? For example, ideas, concepts, statistics, data, all of that, which is not capable of registered as a statutory intellectual property, but used in a looser sense, widely used as proprietary information. So what happens to such outcomes? So typically, intellectual property, if you have a contract where you think there is creation of valuable intellectual property that is price sensitive and that you would like to have rights to use in future, you should pay a closer attention to intellectual property. A typical context for that would be employment contracts. Now, employment contract, a lot of times what happens is that people don't want to hire employees. They want to hire consultants. Now, consultants are service providers in a way. If you take me up as a consultant, I'm providing you legal services. So I'm not your employee, even though I'm providing you certain services. Now, there is intellectual property. Say I drafted a legal advice for you or an opinion for you. Now, there could be certain intellectual property that is there. Say, for example, I would analyze your structure, or I will know about your employee details, your share capital, and all of those details, which probably nobody else knows. Share capital is a wrong thing to state, but assuming I look at your business model and I comment on it from a legal perspective. Now, there is intellectual property, there is confidentiality involved in it, and you want to make sure that I do not later at a point, because I provided you services and I said that yes, this is a correct structure, a legal structure, and you can follow it. Later, I should not be in a situation where I say that, oh, this intellectual property is also mine because I invested time and energy in analyzing this structure and vetting this structure and approving it, so it's mine. So what are you going to do? You are going to put in a contract with me to say that any intellectual property or proprietary information that I share continues to remain with me and doesn't pass on to you. So you will see clauses on IP. Apart from that, of course, you will see clauses on governing law and dispute resolution. I will not talk about it. Perhaps if you have questions on what is governing law, dispute resolution, and you want to understand, I think Dhruv is a better person to answer those questions. But I will quickly jump from here to saying, to start talking about things such as employment contracts. Now, what exactly is an employment contract, or what is employment to begin with? Now, employment is simply put a master-servant relationship. Basically, one party has full power and control over the other party in terms of what work has to be performed, how it has to be performed, when it has to be performed, what, how, when is controlled by another party. The difference of that is a professional, a service provider, where there is freedom in terms of what work needs to be done, when it needs to be done, and how it has to be done. Now, the fundamental test of employment is control and supervision, because one party controls the other. Now, in that matrix, while I do not know if a lot of organizations here have put in employment contracts, I personally think putting in an employment contract is one of the most important things that you should look at when you are scaling up, when you are onboarding people, because there you need to have rigorous contractual requirements in terms of confidentiality, intellectual property, how you can terminate the contract. Now, termination of employment is a regulated piece. So termination clauses in contract will be that there will be clauses where you say that either party can terminate with 30 days notice. I give you a 30-day notice, I want to terminate the contract, I terminated it. There is another thing called a termination for cause. Now, what is the cause? Say if I am your employee and you gave me a bunch of keys to safekeep and I lost them, as a result of which there was a theft that happened in the office. Now, is this a termination for cause or not? The simple answer to that, yes, this will be a termination for cause because I was negligent. So there are certain things like negligence, misconduct, sexual harassment at workplace, a breach of applicable law, doing certain criminal activities, consumption of alcohol while on work. All of these things that have been recognized under several court cases as termination for cause, and typically in your employment contract, you can have them listed out. You can always rely on your employment contract to actually terminate your employees. Now, employees can be of two kinds: blue collar, white collar. When it comes to white collar, basically they do managerial, supervisory, and administrative work. In nutshell, that's the meaning of white collar. Now, white collar employees, for them, contract even becomes more important because they're not as much regulated as blue collar. On the contrary, if you are hiring somebody somebody who is a blue collar worker. Now, who is a blue collar worker? Somebody who is doing unskilled, manual, clerical job, like people who are employed in factories, or somebody who comes to do the housekeeping, or somebody who is guarding the gates, or a clerk. All of these are blue collar employees. Now, when you want to terminate blue collar employees, you need to, as a thumb rule, follow the principle of natural justice. What is the principle of natural justice? That means you have to give them an opportunity to explain why they did what they did. Okay, you cannot be it cannot be that you decided, oh, this person lost the keys and I should fire them. No, you have to give them a written notice, call them for a hearing, sit with them, find out why it happened. If after that you believe that you want to terminate them because he was absolutely or she was absolutely negligent, then you go ahead with termination. But the process doesn't stop there. Why? Because we are talking about blue collar workers. Now, blue collar workers are obviously regulated under several laws, several employment laws, the primary being in Industrial Disputes Act. Now, recently what the government has done is that there are some 50 odd laws in labor under the labor and employment umbrella. And what happens in labor and employment laws is that there's a central government law. Okay, the central government comes up with a central statute. Now, each state, labor and employment, each state has its own powers to adapt those laws, amend those laws as their own state laws, and make rules for them. As a result of which, barring a very minimal number of laws, such as Payment of Bonus Act and Employees Provident Fund Act, many states have actually adapted the central statutes with their own modifications as state laws. For example, Odisha Shops and Establishment Act. The central law is Central Shops and Establishment Act. The state law is Odisha Shops and Establishment Act. Now, anybody who has a shop or has a commercial establishment or an office and has certain headcount necessarily needs to get registered under Odisha Shops and Establishment Act. The place where you should go and look for these laws is your Department of Labor and Employment. You go to the HR department and see there as to what are the acts and rules that are applicable to your organization. Now, as I said, there are some 50 odd laws that you will be talking about as and when it applies. So to simplify the process, what the government has done is that the government has consolidated, or the government has consolidated all of these 33 labor laws into 4 codes. Okay. However, none of them have been implemented. They have all been notified in the Gazette. They have made laws, but not yet implemented. Now, once they get implemented, you will see that existing laws will no longer apply and these codes will apply, and it is going to simplify the process because you know there is one law that you have to follow for ABCD aspects. If any time you hire employees, I need you to remember that until and unless you reach 10 as a head count, a lot of employment laws do not apply. The moment you exceed 10 as your head count, in that case, you should start looking for laws which will apply and ensuring that you are complying with them. I also want to say that irrespective if you are a sole proprietorship or a partnership or an LLP or a registered company, or even if you are doing not-for-profit charitable work through a Section 8 trust or society, you continue to remain as an employer under all labor laws, and you have to start complying with them when your headcount is generally the headcount threshold is between 10 to 20, and there are also salary thresholds. 15,000 and above is a safer place for salary where a lot of compliances do not apply. But if the salary is less than 15,000, you will see a lot of compliances getting triggered for those sort of employees. So that is a generic idea of employment laws. Fundamental registrations that you need to do irrespective of the headcount is that you have to get yourself registered as a commercial establishment from day one. Now, how does that registration work? Of course, you need to have a premise. Now, that premise could, unlike incorporation process, where the premise could be actually your home, you can give that address. Sometimes what happens is that when you're trying to give that premise address for establishment, commercial establishment registration, there could be objections, but it can be fairly explained that this is the nature of work that I'm doing, and this is why my home is my office address. And that is a very simple matter. This registration typically is renewed every 5 years. You have to be mindful of that. I am not sure if the Odisha government has made it online, but a lot of states have done it online. So you do not have to go and physically meet someone and get the filing done. This is a fundamental registration. So the moment you get your companies registered, the next thing that you should know is that within 30 days of your business commencement, you have to register yourself as a shop and commercial establishment. Now, that is one law that I will request everyone who wants to set up a company or any other unincorporated structure also to read, because that essentially applies to commercial establishments. Now, if you are looking to set up a factory, of course, you will have to do a longer process of getting registered as a Factories under Factories Act, which I'm sure is not very relevant in the given context. In the context of employment, Dhruv, I think you wanted to speak a few things about Esops.
Yes, but do we have time? If we don't, I'm happy to skip that and take it up in Q&A if somebody has anything. Manish.
Yes, we are having a lot of questions. So
Yeah.
I will request if you can just wrap up within 5 minutes. Then.
Sure. No. Absolutely. So if you have 2 more minutes, then I'll speak. Otherwise, we can go straight.
Yeah, sure. Within 2 minutes, we'll be okay.
Okay. Thanks, Rajmi. So very quickly, thanks, Arya. I just want to touch base on another issue that typically comes up for early stage companies, right, which pertains to Esops. Everybody knows what Esops are, but very few people really understand how it works. Common mistake. You get an employee, you're a founder, you get a techie to come and join your team. The techie says, okay, how much salary do I get? Early stage, bootstrapped, don't have too much money to pay. You give him a letter saying, I'll give you 1% of the company in the form of Esops. It's a mistake that I have come across, at least in my experience, about 60 plus startups make, where they end up giving Esops through that letter. Doesn't work like that, unfortunately. When you have stock options, when you give stock options to somebody, always consult a consultant, okay? Simply because you need to have an ESOP scheme in place. That ESOP scheme needs to be adopted by the board of the company, and only then are you in a position to give stock options. So what are options, right? They're basically a right that you give somebody, okay, I'm giving you 10 options. They will vest upon you, say, over a period of 1 year or 2 years or 3 years. And once they vest, you can exercise them and convert them into shares. Then they'll become shares, and then you become a shareholder. And then once you get a chance to like liquidate, which means that there is somebody who's willing to buy those shares, is when you make money. Okay, that's the ESOP process. But as a founder or as a potential employee for a startup, getting a letter simply saying 1%, 2%, it means nothing. Stock options should always be mentioned in terms of numbers, because you're 1% of what, right? You may start off with a capital of 10,000 rupees or 1 lakh rupees or 2 lakhs or 5 lakhs. But that 1%, by the time you actually end up exercising it, could become, your capital could be a lot more. So founders typically will just give a letter. Here, I'll give you 1% of the company. And that's a huge mistake, because again, I've seen instances where that's led to disputes. That's led to fights amongst founders and their senior CTOs, etc. So be very careful as to how you actually introduce the concept of ESOPs in your company. And if you're an employee getting ESOPs, you have actually asked the right questions. And the other thing you want to be careful about, which is what sometimes happens, that when employees exercise their options, which means that they are now converting the option into shares, they have to pay tax. Unless you're a very, very generous company and take on the tax onus on yourself and say, no, I will pay tax on behalf of you, which most companies don't, you will have to ask the employee to cut you a check off the tax amount, and only then do you issue shares. Otherwise, there will continue to be a liability of tax in your books. This is tax that's called a perquisite tax. You don't want to get into technical jargons right now, but all you need to know is that needs to be taxed, right? So again, it's a mistake that founders do, and you want to be very, very careful about how you actually implement an ESOP scheme in your company. Always talk in terms of numbers, not percentages, and make sure you follow the right process in terms of having a scheme which talks about different things. That what happens if you fire the employee? How many will he continue to get shares? If he's leaving the company and he's become a shareholder, do you also want him to then assume he joins a competitor? He continues to be a shareholder in your company and works for a competitor. So all of these aspects are actually covered in the ESOP scheme. Very important document. That's all I wanted to throw out there. Just food for thought for all of you to keep that in mind. And Rashmi, we can move on to questions. I didn't want to take too much time on this.
Yeah, thank you so much. Manisha, you can go with the questions.
Okay. Thank you, sir. Thank you, sir. Thank you, ma'am. It was a pleasure to you. Thank you for providing the in-depth knowledge and brief insights about the topic. I'm sure there's a lot to take away. Quickly jumping to the Q&A session, I guess there's few questions that I would like to address. There's one question, there's actually a few questions related to Section 8 company. So I would like to address this question. What all the works can be done under Section 8 company? Can we carry on more than one activity under Section 8 company? So I would request any one of our mentor would like to address and answer this question.
Madhu, would you like to take that question?
Yes, ma'am. Okay. So actually, in case of the Section 8 companies, there are certain allowable activities like you cannot go for the activities which we are basically normally do under the private companies, because in case of the Section 8 company, the activity must be of certain social importance like promotion of art, science, culture, development related activities. That only you can do under your Section 8 companies. Means basically the activities which are of the social importance. But one more question actually I was seeing in the chat box that whether we can go for multiple activities under a Section 8 companies, then yes, you can go for the multiple activities under the Section 8 company, provided the activities must comply with the activities given under your Section 8 type of companies. It's like the social importance activities. And if not, if in future also, if you want to add any activities to the your memorandum by changing the object clause also, this is also allowed under your Companies Act 2013. Thank you.
Okay. So there's another question.
Manisha, 1 second. If I may just add, if people here say, I'm sure because Odisha is a place where there is a lot of art and culture, and art and culture doesn't need to be only as somebody who is doing charitable activities or promoting art and culture. We have a lot of potential where we can sell art and culture and make money, starting from handloom to Pattachitra to all of these things we can do. So my point is, if somebody's business idea is to make profit or revenue out of it, Section 8 is not the model that you should follow. Don't go by what internet is saying. Probably get Madhu's number, because one of the conditions that you need to know is that Section 8 companies do not allow you to distribute dividends. Anything that you generate has to come back to the Section 8 company. So it's just not social importance. It has to be a charitable activity. That means you cannot take back profits into your own pocket. So if your art and culture is what you're looking at for revenue, please consider the other options. Thank you.
Thank you, ma'am. Moving to the next question, there was a question, can a LLP company eligible for foreign investments? If any one of our mentor would like to address and answer that.
I'm happy to take that if someone wants to add. Look, LLPs are allowed to now, in fact, since a couple of years, are allowed to, the question was with respect to funding or foreign investment?
Foreign investment.
Okay, so LLPs are, for the past 2 years, LLPs are allowed to raise money, but they're only allowed to raise money in sectors which for the government of India fall under the automatic route of raising money, right? So if you're actually raising money in a sector that's regulated, where the government has capped FDI limits and there are a lot of press notes and notifications that have come out in the recent past as well. If you're if you're running any kind of digital media, for example, there is some ambiguity that has come up due to some recent notifications. But essentially, if there is a sector where the government says, if you're a private limited company and 100% FDI can come without taking approvals from anybody, and that business can be done in an LLP and you can raise money. But if it's in a business where you have to take the approval of a government, even beyond a certain percentage, if you're raising FDI, that business cannot get FDI in an LLP.
Okay, thank you, sir. So there's another question. What are the pros and cons of having funding from electoral bonds?
Dhruv, you want to take that?
Sure. Okay, very complicated concept for early stage companies. Let me say that. It's a manner of fundraise that's done by fairly large institutional companies. I don't know too many tech companies or early stage companies that have actually raised money through bonds, in manners like this. The benefit, of course, is the kind of rights that get associated with it, and the kind of dilution that happens and at what states that dilution happens. If you're asking for a certain sector, now, for example, in the renewable space, it's a very common activity. If you're a solar generator, power generator, solar distributor, like a power distribution company, a lot of these companies raise money through these bonds, through electoral bonds. But again, if you're in the tech space, and if you can, whoever has asked this question can give me some perspective of the industry that they want to know this about, I'm happy to give you some practical insight as well. But the fundamental benefit, even for these larger organizations who actually use this, is the rights through which they actually raise money, and the kind of rights. And okay, it's an entertainment industry. So again, I'm not sure if there are any precedents of bonds for like smaller scale companies that are just about starting up. Like I said, the benefit is in terms of the rights that get associated with the bonds, the future dilution that takes place when they get converted. A lot of the rights that get associated with these bonds are that they will, at a future date, they will have a right to get it converted into equity. And of course, often they fall within the domain of the Securities Exchange Board or SEBI as well. So most companies, or at least early stage tech companies, try and stay away from that. But again, just on a theoretical concept to address your question, I think it's generally to do with the rights that get associated with it, which you can contractually agree, which don't necessarily need to comply with the provisions of shares as such under the Companies Act.
And if your question relates to the one that is specifically initiated by the current government with respect to electoral bond scheme, that is very limited. The purpose for those bonds is that you give them to somebody and somebody goes and encashes them. Instead of making cash payments, say if I want to donate 50,000 to an organization, what I can do is I can buy an electoral bond from a SBI branch, and I can hand over that bond, and the bearer can then go and encash it. So, I mean, that again, that bond has its own limitations. If you are referring to electoral bond under the scheme of, I don't remember the year, 2017 sometime. I think it came under Finance Bill 2017, not sure. If you're referring to that, then I clearly remember that that is not something that can be used as cash or, like contribution towards the company's capital. It has contribution to political parties, and donations was the purpose of electoral bond scheme.
Yeah, in terms of transaction, right, it becomes a form of making a certain kind of payment, not necessarily a mode of raising money for a private company.
Well, thank you. There's a question related to Startup Odisha, so I would address that question. So there's a question, how can we generate business under a trust, and can a trust eligible under Startup Odisha initiative or Startup India?
Okay, so under Startup Odisha, even after under Startup India, there is no provision for any trust. So we only welcome private limited companies, LLPs, one-person company, and register partnerships. So trust won't be a profitable business. That's why we are not welcoming that.
Okay. Thank you, sir.
A trust can't give equity, right? So like from a startup perspective, there is no incentive for investors to come on board, etc., or for an incubator, etc., to then take some sort of an equity when they support them. So that is in a trust model that will never work, right?
Also,
Yes, yes.
Manisha and Rashmi, I wanted to tell everyone who is attending, people who are looking for social impact based activities, I mean, there is nothing that prohibits them to actually do it through a private and an LLP structure. So if the impact that you're looking for is, say, rural education, if that's where you want to work, in fact, my personal experience and suggestion, professional recommendation is that do not go through a trust or a Section 8 or a society, because it is very difficult to take out money or get in money into those structures. The regime around that is very regulated. You can do all of those activities, have an extremely brilliant social impact idea, and house it in a for-profit making private company or a LLP or a partnership.
Yes. Thank you, ma'am. Like there's recent questions that is coming up. I would like to address one last question. There was a question about what penalties are there if we are not complying the ROC matters. And there's also kindly provide Madhu ma'am's number. So I would request her to address this question.
Yeah, especially for this matter, that there are lots of penalty provision under ROC, means ROC non-compliances. So actually this penalty provision varies from your activities to activity. Like you means in general, if I'll say, then per director, this is 50,000. Your per disqualification or per non-compliance, which can be extended up to 5 lakhs of rupees, along with a 6 months of imprisonment, starting from 6 months of imprisonment up to 1 year to 6 years of imprisonment. Rather, this penalty actually depends upon the type of the non-compliance. But yes, there are strict non-compliance penalties are there if you are not complying with the ROC provisions.
And just to add,
all the details of penalties and all, you can also access to the website portal to get the details.
Yeah, no, absolutely. And just to add to what Madhuji said, it really depends upon the nature of offense that you've committed. And if you are in that space, whoever asked that question, if you are actually experiencing that, then consult with somebody to evaluate whether you can go for compounding. Compounding is a way where you go and accept your mistake. You say, okay, look, I made this mistake, but I'm willing to get it compounded. And if there is a penalty that has triggered or has arisen or has accumulated over a period of time, and say if it's, hypothetically speaking, if it's 10 lakh rupees and you go and get yourself compounded, compounding happens before the National Company Law Tribunal, and the NCLT can then reduce the amount from like 10 lakhs to even 50,000 or 1 lakh and say, okay, we have, compounded this offense completely. Now make sure you don't do it, pay this penalty, and the offense is over. So make sure that you're talking to somebody about that.
Thank you, sir. So with that, I would like to wind up the Q&A session. And I hope
Manisha, Manisha, sorry to interrupt. I have few questions for our mentors. Arya, I have a question. Few days back, one of our startups, he had a problem with his vendor. So they were having a contract, and the startup is into a tourism sector startup. So their vendor is from Delhi. So after receiving the order, even after following up a lot of times, the vendor is not doing the payment. So now what will be the next step for this startup? So these kind of problems are facing by, I think, many of the startups who are into early stage, but they don't know about the legalities, what action they should take.
Honestly, if that person is not following up, I want to see the commercial terms. I cannot just say, but typically general idea, you will have certain things in your contract, or there is some promised term. There may be email exchanges if there is no contract for this particular aspect. You will have to send them a legal notice in the least, to at least pressurize them to make payments. But I am available. If you wish, you can always connect them to me, and I can give them a preliminary advice basis review of their contract. I can call and speak to them.
Sure. Thank you. Yeah, Dhruv, there is a question from one of our startups. As you were talking about the trademark of logos, and so his question is, instead of going for logo registration, is it possible for go for like name registration?
Yeah, trademark applications are effectively of two kinds. One is a word mark, which is the name, right? So today, if I want to get Startup Odisha registered, it is STARTUP Odisha, like the words, right? That's the
Right.
word mark. You can register that, and then is the way it's written, the color scheme, the background, the font. That's the logo, right? That's that can also be registered in whatever permutation combination. And the point I was trying to make is that depending upon the nature of business you're in, depending upon when you will start generating revenue, the idea is when do you spend money and what kind of money in getting what kind of names registered. So if you are not going to generate a lot of revenue upfront and you want to save cash, the least you should do is register the word, because that word will give you protection even if someone is copying your logo or your entire word is used in your logo. So it gives you some level of protection. As you grow, as you started making more money, then go and file your other trademark applications as well, which more than likely you are to get because you already have a word mark registration with you, right? So that, but you, to answer your question, yes, you can get the word mark registered as well.
Okay. So one more very simple question is that many of our startups, they are trying for investors, but there is some queries are coming from investors. They are trying to invest on their companies, but they are confused about whether this investor is true investor or like they are just going to play with them. They are also charging like equity not in a normal number. So I hope you got my question.
Yeah. No, wait. So are they charging? Are they asking for equity for consult? Like I didn't get it. If they invest, of course.
Both they are asking. They are asking for like documentation and also for equity.
No, equity they will ask for because they're investors. But are they asking for equity without investing?
They will invest if they are going to agree with the contract that yes, this much of amount we are going to spare after this investment.
Okay. So there are two aspects to this. First is sharing data with potential investors, right?
Okay.
Sharing your business plan, sharing what you're trying to do, even showing them your code. A lot of that happens, and I think it's the most tricky situation for any founder. Because you think if you over disclose, he will get all that information, then he will go to some other company and he will share all that information. That doesn't just happen with angel investors. There are instances where that has also happened with institutional investors. Like the bigger venture funds will also come and talk to you. And if they think it's worth it, they may go to some other company of theirs and do it. The low rank associates who work in these venture funds, a lot of them also just cold call different companies and ask, oh, I'm calling from XYZ fund. I've heard you're doing this. Tell me about your product. What have you done? What kind of milestones have you reached? What kind of product is out there? They will gather all of this data. It's a very standard exercise. Unfortunately, Rashmi, it's a gamble that startups have to take, because I've also come across instances. And, when I was starting my career, I used to tell startups, it's okay. Ask the investor to sign an NDA. Some investors did. But a lot of them were like, look, you want money from me and you want me to sign an NDA. Forget it. I don't want to talk to you. But the thing is, in terms of a trade-off, what are you better off doing? Are you better off perhaps disclosing a little bit or just letting go of that investor completely? So it's a gamble you have to take. And from the investor's perspective also, it's reputation driven. If the investor then gets that reputation that he's stealing ideas from different startups, in the long term, it's going to bite him. So I don't think investors actively do it, but have there been cases where it's done? Sure. But unfortunately, if you need money, that's a bit of a gamble that you need to take.
So is there any due diligence fees they are charging from startups?
No, of course not. Due diligence fees is when an investor is looking to invest, they get a due diligence done at their cost, never at the startup's cost.
Exactly.
Once that is done, and then they look to invest, then what typically happens is, for early stage companies, they could be raising like 50 lakhs or 1 crore or 1.5 crore, right? Small amounts of money. And at that point of time, the legal fee, whatever it is for the documentation that needs to be prepared, sometimes the investor gets their lawyer, because you don't need two lawyers to like overcomplicate the deal and then two lawyers to make money out of the whole thing. So typically for early stage deals, you will have one lawyer who will make sure that the deal is done properly and documents are more or less standard and without getting too complicated. So the investors then ask that, okay, my lawyer's fee is like X amount of rupees. The company should pay that eventually. So that they may not pay, but that only happens once the deal is closed, the startup has got the money and now they need to pay. But to say upfront, I will do a diligence, then I will decide whether I invest or not. And the diligence is going to cost 50,000, 30,000, 1 lakh, 1.5 lakh. You need to pay that upfront, whether or not I invest or not, no way. Never agree to that.
Okay, fair enough, fair enough. Okay, with this note, we will conclude this session. So I would like to thank Mr. Dhruv, Ms. Arya Tripathi, Ms. Madhuchanda for sparing this much of time and sharing their valuable thoughts and insights on various topics. And it's really wonderful session for us. I would thank all the participants from outside Odisha and those who have participated from Odisha itself. I would like to thank Startup Odisha team and Manisha also. Thank you so much. With this note, we are just concluding this. Thank you.
Thank you so much.
Thank you, sir. Thank you, ma'am.
Yeah.
It was a pleasure having you as the mentor for today's session.
Thank you.
You.